All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning is League of Women Voters of Florida versus Scott.
Good morning, and may it please the court. I'm John Mills on behalf of the petitioners. And I believe I've reserved 7 minutes. And if I may, just so I don't forget during the argument, I would like to begin with an apology to my good friend and esteemed colleague, Mr. Cantero. Apparently, some people have read our petition as accusing Mr. Cantero of not being forthright or of not providing documents when requested. No such insinuation was intended, nor would that be true. He's been nothing but highly professional throughout, and we have tried to coordinate and communicate in ways to make things as easy as possible with the court, and I very much would regret any suggestion to the contrary. There are 3 issues before the court today, and not a single one of them depend upon who won the election on Tuesday, if we even know that answer yet. Nor are these issues unique to today's situation. These are issues that are likely to recur and should be.
Let me ask you that. Some of the, in view of the passage of the amendment concerning mandatory retirement, which now has a provision that was adopted by the people, that will have, it's been prospectively adopted, a provision that will require a uniform rule of retirement no later than the age of when the person turns 75 years old, which is different than what we have now. And although we have colleagues here who are subject to the mandatory retirement, the way it is operated under the current version is that they're required to retire at the end of their terms.
Correct.
That's not going to be happening in the future. I think under the new constitutional provision, we will never face a situation similar to the situation we face now, unless we happen to have some extraordinary coincidence of people having birthdays that are at the end of a term.
Yes and no. Yes, first off, even before the amendment, if a justice resigns, the vacancy occurs when the resignation is accepted, not when they leave. That's already been decided by this court. So that's not even the scenario here. Or if somebody dies, all these other reasons somebody could leave. The only scenario under the current Constitution we're talking about is when somebody serves out their final term. In this case, it happens to be the reason this is their final term is because these 3 justices cannot run for another term for retention because of mandatory retirement. And yes, that change will remove that from happening because under the new, effective in July, when you hit your 75th birthday, you're off. Even if it's a day left in your term or whatever, that is gone. However, the same provision would apply, and where this could recur is if a judge or justice was ever not retained. There's a retention election and nobody's ever not been retained yet, but it could happen. Or if judges or justices decide not to seek retention even though they're eligible and they don't file the paperwork. Or if they forget to timely file their paperwork. Or any other reason they don't qualify for retention, some problem with the paperwork, whatever. In all of those circumstances, there's a specific constitutional provision that is not amended that says they complete their term and the vacancy occurs after their term has expired. So this can recur. It would not recur in this situation of mandatory retirement, but it could recur with a failure to retain or a failure to seek retention.
But are you still seeking I want to understand if, in light of our order, unanimous order that stated that it is the incoming governor that has the authority, you have, are you requesting, one, that the nominations be reopened?
The applications, yes.
The applications. And then two, though, and this is the part that I think is of concern, that everything stops. And if you can address those separate, in other words, the relief that you're seeking, because
Sure.
previously, in your first petition, you conceded that the JNC could start its work earlier.
We conceded the Constitution did not prohibit that, correct?
Okay. And that extending it to, say, December 8th, I think what you said is a date that would be then 30 days or so before. So what's the reason for your changed position, and why should we not go with your original position?
Let me explain, because we have not changed any position. We maintained the position in our original petition, and we filed a supplemental petition. We're seeking three things. The first thing, and the only thing still relevant from our original petition, is we're seeking a determination from this court as to when nominations can be made. And under that provision, there's no prohibition on accepting applications, being ready to make nominations beforehand, but it's just the question of when can the nominations actually be made. So that's issue one, and I want to get right into that in just a moment, but to be very clear, issue two is that the commission had no authority to set the October 8 application deadline. It has no authority under its rules. The Constitution doesn't speak to this. The Constitution has no substantive provision that says, thou shalt not accept applications before the vacancy. And their rules could be constructed in a way, as Justice Quintero explained. I think he only had one other vote. The majority may have disagreed with him, but I understood his reasoning to mean that as long as the commission's rules authorized it to accept applications before and start interviews or whatever, it could be ready to make the nominations at the earliest possible point. And what we've said is that their rules don't allow that.
Okay. Are you distinguishing between nominations and certification? Because the courts, again, ruled certification cannot occur until the new governor is in. It's Article 5, Section 11C, which governs this, also talks about the nomination shall be made within 30 days from the occurrence of a vacancy. So it would seem to me that nominations and certification are essentially the same.
I think they are the same thing. We're not seeking to distinguish. Is it hypothetically possible to make the nominations and then certify them 2 months later? I don't know how you could do that. That doesn't make any sense to me.
Well, it seems like the Constitution doesn't
I agree.
allow it.
I think you have to read those two sentences together, and when you do, it's just a simple timeline.
But so therefore, what is your best argument for why the process, and I agree that if the deadline was set based on the governor's letter, that nominations should be reopened, but what is your argument that nothing can start until after the new governor is sworn in? It's because if the JNC changed composition, if the statute said with the new governor there will be a new JNC, we would have a different ballgame. But here, the JNC composition does not change.
Well, it is not required to change by the Constitution, but certainly when any new governor takes office, I think it's traditional to ask all appointees to resign, whether their terms are up or not.
Has that ever happened with JNCs?
I'm not sure if it has. I'm not sure if it's ever been politicized like this, and I have no idea if that could be done or will be done. I don't know if either governor would intend to do that. I think that would be entirely within their prerogative, and I think it would be inappropriate for me to assume one way or the other.
Let me ask you this, because I'm a little confused. Explain to me, what is it that you're saying that can be done before the vacancy occur and cannot be done? What can the JNC take applications? Can the JNC interview people? Can the JNC, do all those things? What can they do and cannot do? What are you saying?
Okay. Our argument is, and this is under our supplemental petition, this is the second issue before the court today, is that the Constitution requires them to follow rules, and it puts restrictions on those rules. And when you look at those rules and those restrictions, the answer to the question is no. They cannot accept, they're not supposed to accept applications until the vacancy occurs.
Okay, so-
We are not saying that the application submitted should be thrown away. They've been accepted. I don't see there's any harm that they've been accepted. Most of them have been interviewed. Probably before there's a ruling, they will all have been interviewed. That's fine. That doesn't go away. We're just saying that they're really supposed to wait by their own rules until January 8th.
Well, so your argument from the first petition has shifted from an argument that would delay the certification of the nominations until the new governor takes office, to an argument that would essentially preclude the process from getting started until the new governor takes office. So, so under the scenario you're outlining with this supplemental position, this court would be in the position where there would be, these positions would be unfilled or filled in some other manner, but the new justices would not, the process for selecting them could not effectively start until the new governor takes office. Isn't that correct?
Under their current rules, it's not a change in our argument, it's an entirely new argument. We could
Well, I
have filed it
understand
as
it's an entirely new argument.
It is. And listen, if this commission had amended its rules to provide for receiving applications before the vacancy, as long as it should have been after the election, but whatever, they could have made a rule.
What could
and that
preclude
rule,
them from doing that now? Assuming your argument about the rule is correct, what would preclude them from doing that now?
I'm not aware of anything other than we're going to ask you as our third to stop everything, and you may not do that. And if you don't do that, they absolutely could accept it and say, and then they'd have a rule, and they could follow the rule. I can't imagine they would pass a rule that would retroactively set a deadline so that people can apply. And more, if I may, more importantly, their rules, they are required to follow their rules. You review their rules. The legislature reviews their rules. They can be repealed. So if they said you have to apply 6 months in advance or before an election or whatever, you should repeal that because that's not fair. Or the legislature should. You at least must have the opportunity. You've been denied that opportunity.
But the issue, again, in answer to Justice Kennedy's question, is that previously, you, in your petition, you suggested the date of December 8th for, you're looking...
I don't remember it being December 8th.
Well,
I think
it was something in December. I recall this.
Yeah, I think we said if they did it December 8th, that would give them 30 more days than they normally have.
All right. So now what I would ask you, though, is in answer to Justice Labarga's question, the only thing that you say stops the JNC from acting now to interview, do background checks, is their own rules. Is that what I'm understanding?
It's two parts. That's the main part. But even if their rules authorized it, now that we have seen their records, and I believe they have given us the records of all of their meetings, they did not have a meeting. They did not have a majority vote to set the deadline.
And we're not, let me just say, this issue of the public, that issue, I feel we're here to try to get this constitutional issue straight. And for one, the issue of whether there was the meeting to set the deadline, I mean, my question is really, I don't think they have the authority to begin, like, they knew, everyone knew that when we were going to retire, because they know our age. If they started last year on their process, absent the governor directing them, I'm not sure the JNC has independent authority to just start the process. So that's another question. But given that they've now started the process and that no JNC and no governor has ever interpreted their own rules, which I read before your first petition, or at the first petition, to interpret that to mean they can't start the process until there's an actual vacancy. I mean, so even though it says it, there's no way in the way it's both operated, is there? That the vacancy means for them the actual vacancy.
I don't see, there's been no argument as to why the same exact words in their rule that tracks the constitutional language that this court unanimously said, when you use those words, that means you can't do it until the vacancy. They knew that, everybody knew that, Justice Cantero told them that.
One thing we know,
Hmm?
one thing we do know is that vacancy, the word vacancy in different contexts means different things.
Yes, sir.
I mean, that is clear.
Yes.
And
Mr.
so
Mills?
the sense in which they're using it in the rules is not necessarily the same sense in which it is used elsewhere. Wouldn't you admit that?
I think it can be used differently in different contexts, but not in different documents. When their rules in the Constitution are using the same words in the same context, the contexts are no different, they should have the same application. And even if they were allowed to interpret their rules as they have, they still have to act by majority vote. There has to be a meeting, the public has to know about it, and they have to vote. This was a controversial application deadline. The public, when the public has learned about this, you have amicus briefs from all kinds of organizations saying, hey, we want to apply.
Before we move to something else, I cannot think of a deliberative body in this state or anywhere else that can't waive its own procedural rules.
Your Honor, this one cannot, and the reason it cannot is because
We do
the other
it,
bodies...
the
that you're
legislature
talking-
does it. I can't think
I
of a
can tell you why.
deliberative body. Okay.
Yes, the reason why is there is no rule that says the legislature must follow its own rules and its rules can be repealed by another branch. These rules can be repealed by you or by the legislature. If they can just waive and not comply with their rules, then that requirement that's in the Constitution means nothing. Then the legislature can't repeal their rules because they don't have to follow their rules. You can't repeal their rules because they don't have to follow them. They do have to follow them as a matter of constitutional law. The constitutional provision requiring them to have rules and making them subject to repeal is unique. There's not another commission or body that I'm aware of that has that. That is binding on them. If they don't have to follow their rules, then your right to repeal the rules is absolutely meaningless. And you should not interpret the Constitution to have something like that be meaningless. You have to have the right to say, no, you can't do that, and if you appeal a rule, they better not follow it anyway. And
Well,
the corollary to that is if there's a rule, you know what they are, you haven't repealed anything, you are entitled, the public is entitled, to have them in this most solemn occasion follow their own rules.
Well, Mr. Mills, I'm still puzzled by the way this has evolved, because this was an argument that would have been available before the supplemental petition was filed.
I didn't have the information that was available. I had asked, so the rules say they're effective 2016. I didn't know they can amend them. At the very last thing, they can amend them at any time. I would assume that this body would follow its rules, and if it wants to vary that, would have amended them.
But forgive me, I thought you were saying that the rules require that they can't accept the applications until the vacancy occurs.
Correct.
The physical vacancy. Now, that obviously was an argument that's been available to you all along.
I haven't known what their rules were, sir. That's what I'm
aren't they
saying.
Well,
They
but
can-
what do you mean you didn't know? Well, but that's publicly accessible information.
Sir,
The state of your knowledge is not really at issue.
It's the
This
public.
is an argument that was available to you, and if I remember your original petition, you
Embraced
were essentially saying it's fine for them to go ahead and get started. You quibbled about the timing. You thought maybe it should have been a little later, although you didn't tether that to anything in the Constitution or anywhere. But you basically affirmed their proceeding with the acceptance of applications prior to the end of the terms that are to be filled. Isn't that correct?
No, sir, that's not correct. What I affirmed is that the Constitution did not prohibit them from doing that. I presumed that this commission, as they are entitled to do, had a meeting and said, we better amend the rule because we want to start early, and amended their rule, which they're entitled to do, and had minutes, and I'd be able to see that there was a majority vote and that this was done. They had every right to do that, and I wasn't going to presume that they didn't do that. Nowhere can I find that out other than by asking them, can I have all the minutes of all your meetings? And so I've done that. I asked Mr.
So the
Quintero-
amended rules become effective before they're reviewed by this court.
I believe so, yeah. There's no provision that upholds it. Yes, if they had a public meeting tomorrow, or whenever, I think they have to give some advance notice. If they publicly noticed a meeting that we're going to consider a new rule change to allow applications before a vacancy, they can do that. And if they have a majority vote, that's going to be the rule until it's repealed. They haven't done any of those things. If they did those things, they'd have a deliberative session where they would have to consider that since the application deadline, the qualifications for being a justice have changed. The age has gone up, so there may be people who would apply who were not even eligible before. And they know that all of the African American bar associations, the women lawyer associations are saying, there's no speculation like they suggest in their response, they say it outright, they have members who want to apply but wouldn't apply when it looked like Governor Scott was making it. Governor Scott's
Let me ask you this.
But isn't it the case that it has been known for a long time?
Absolutely. It's not a lack of notice.
That there was much controversy swirling around how these appointments would be made.
Absolutely.
And how that would work. That this is not news to anybody.
Nobody. You are 100%
and isn't
correct.
it also the case that in applying for judicial positions, one of the key factors that is always operative is uncertainty.
Yes,
no
sir.
one ever knows how that process is going to turn out.
Right.
And if people that wait for certainty or for a higher degree of certainty in that process are going to be waiting for Godot. I mean, it's not coming. That's just the nature of the process. And so this was a known uncertainty, and people, I'm struggling to understand why people are entitled to a higher level of certainty.
Your Honor, I don't think I'm saying people are entitled to it. I'm saying that that's what is fair, and knowing who is going to make the selections is important.
Well, so you're not saying they're entitled to it? I don't understand. You're asking that we require something as a matter of law. If they're not entitled to it, I don't understand.
They're entitled to have the rules followed. Sir, the rules haven't been followed. They are not entitled to a certain deadline. My only point is if this deliberative body, instead of just the chair on his own, if they sat in a room and they said, whether they agree with you that, gee, that's unreasonable and everybody should have to know that, or they said, well, it's not unreasonable, especially for a private lawyer who, if they file an application, their boss knows they're looking for another job, their clients know they may lose the lawyer, new clients may never hire them. That a private lawyer would have to do that.
That's
true
under any Mr. Mills, I would like to ask you, I don't care why you did or did not do a specific thing at a specific time, but I am very interested in what this court should be doing about whether we open up the procedure, when the deadlines ought to be. So would you please just give me your best argument about what we should be doing? What should the JNC be doing from this point forward?
The two things that are clear, you should issue a writ of quo warranto to say they cannot, their application deadline was invalid, and they must follow an application deadline that complies with their rules. And second, you should say in the nomination.
What is that application deadline? According to their rules, tell me specifically what that application.
According to their rules, as of right now, that application deadline can be no earlier than January 8th. If you want to allow them to, if they change their rules, then it could be earlier. So the last thing that I'm asking for is not quo warranto relief. It is extraordinary. I recognize it is significant. And it is saying use your all writs power to make those remedies meaningful, prohibit them from changing the rules in the game, prohibit any other gamesmanship.
What is the standard for an extraordinary writ?
It's whether the status quo needs to be held in place so that something the court already has jurisdiction to do can be fully meaningful. It's not an independent basis.
And what's the standard for quo warranto?
For quo warranto, it is whether an action, as we now know that has been taken, an official action, is within the actor's authority.
And these are discretionary writs?
Yes, they are.
Mr. Mills, you're now slightly into your rebuttal time. You may proceed or you may reserve.
Okay, let me just go make sure I've got everything I need to. I haven't talked a lot about the training materials and why we believe this is tainted. And I guess with time permitted, we're going to rely on our briefs, but these are very important to us. They're not complying with their rules. Their own training materials show that they're doing ideological vetting. That's not appropriate. It's against their rules. They are not supposed to do that. And that's why we need to freeze this, so that the commission that considers these, to the extent it's okay to accept input from the governor, as they have done and we have shown.
I do have a question about that. I mean, it was curious to me that the basis for that argument that this was a partisan tainted procedure was that there was a video in which the governor had addressed the JNC and said what he was looking for, but you didn't have any statements that were made that would support that. I think it was yesterday you filed a transcript of that, and very short statement from the governor that says he's looking for high-quality people, and then from the general counsel, the governor believes there are many qualities that make a good judge: intellect, ability, experience, diversity, reputation in the community, demeanor, but there are only two that he considers paramount, and he talks about them. The first is that they're committed to the rule of law, and the second is humility.
Things that we would all agree are appropriate
Right.
in all judges.
Okay.
Absolutely, and that's a very good point. And the new governor who is elected should be able to amplify that if they wish and say, in addition to that, it's very important to me that our judiciary reflect the racial and gender background of our citizenry. For 8 years, we've not had a single African American appointed to any appellate bench. It's very important to me that these reflect our population. And so I don't want anybody who's not going to follow the law or be humble or any of those things, but please provide me, as Governor Christ did, have that input. He can't force them to do that, but he should be able to have that conversation. He should be able to say, please don't be asking these questions when you ask about ideology. That makes me nervous, because that's my job, is to determine the right ideology.
But what Justice Lawson just read wasn't about ideology. Do you have someplace else in the transcript that
It was not overtly about ideology. I would respectfully submit that most of the bar and most of the judiciary know when somebody like Governor Scott says, I'm looking for somebody who will follow the law, when he says, you justices, this court have not followed the law before.
This is
activism.
just so speculative. I mean, what was said that was improper? The
Nothing was
words.
said.
Give me the words.
Nothing. Not one thing, sir. He did not say anything.
What is this
improper.
argument about?
The argument is about the new governor should be able to also say not
Is
inappropriate things.
that's not an argument you've ever made. The only argument you made was that things were said to this JNC that were partisan and improper.
I did not.
And we should stop the process because it's infected, I think was your word that you used, with this partisanship, and what you pointed to was what I just read. I don't see any...
Sir, I've intended to point to quite more than that. Articles, public statements that have been said, the viewpoint, you may disagree with it, and you'd be entitled to disagree with it. Many people may disagree with it. But many people in this state and in this bar and on this judiciary believe that this JNC is ideologically vetting. We provided objective evidence that they are, and the new governor is entitled to say, don't do that at all, or if there's some permissible, to share what their ideology is. That's all. This last form of relief, it's extraordinary. We're not entitled to it.
Let me ask
I think
you
it's
this.
within
As a
your
matter-
discretion, and you should grant it.
As a matter of discretion, given the allegations of your petition and what you're saying now, wouldn't it make more sense to let the new governor file something if he wants that opportunity, instead of
Yes.
acting because you're
Absolutely.
speculating that
Absolutely.
he might? Okay.
Absolutely. And the best way to do that is to stay everything until we have a new governor-elect who can do that. Right now, there's nobody
We
who
have
can
a
do that.
governor-elect, and he could act today if he wanted to.
We do not, sir. There's not been election certified. They're still counting votes. And once they're certified, it appears that it is going to be Mr. DeSantis. And if Governor-elect DeSantis is made the governor-elect, he can intervene. He could substitute. I mean, right now, we're here to vindicate the people, the voters. We know the voters voted for one of these two men. And the voters are entitled for that man to have his full authority. Whether that is Mr. DeSantis or Mr. Gillum, he's entitled to have that authority. So if you don't want to stay until January 8th, I think you make an excellent point. until January 8th, or until the governor-elect says, hey, please let this begin, or intervenes or does something, has some opportunity to participate in the process. We don't want to create problems with the court. This has been very difficult. It's been very difficult to draft these arguments in the most respectful way possible. We do believe that this JNC is ideologically vetting. I hope they aren't. Maybe we're wrong. But public perception should matter. It should matter especially when the stakes are this high. And the cleanest process, if they would say we're going to reopen or people can apply now, the election is over, we'll consider those, then largely this becomes moot. The most important things that you can do today that I don't think should be controversial are to say they can't nominate until January 8th, and unless they validly change their rules and have a majority vote, they have to accept applications again January 8th. I think it would be unfair to say they have to disregard the applications that have already been received. A lot of the work has been done. I see no reason to impose unfairness on the applicants or on the commission for the work that it's done. But those two things should be clear, and I hope that you will, the gamesmanship, they continue to say their goal is to let Governor Scott participate in the process. He has no such role. You should stop it. If I am allowed any extra time, I would use that on rebuttal.
How much do you want?
Two extra minutes would be
2
greatly
extra minutes.
appreciated. Thank you very much.
Can I negotiate for time?
You can get 2 extra minutes too. So you get 2 extra minutes to start with.
I hope I won't need it. May it please the court, Raul Cantero on behalf of the Judicial Nominating Commission. With me is George Levesque on behalf of its chair, Jason Unger. And I will be reserving 5 minutes for Dan NORDBY on behalf of the governor. I think that as to Governor Scott, the court has determined the issues in its order. I believe that as to the commission, they have provided no basis for the extraordinary relief of quo warranto that they are requesting.
Let me add on that, because that is, first of all, do you agree with Mr. Mills that nomination is tied to certification? So even though we didn't, in our order, we said they can't be certified until the new governor assumes office. If you look at the language of Article 5, Section 11C, it seems that those nominations, whatever that means, that the names, the 18 names or not, whatever it's going to be, do you agree with that?
Not necessarily. How I interpret the order and the Constitution is the commission can certify its nomination before January 8th, but the 60-day period that the governor has in order to appoint doesn't begin until that governor takes office. So regardless of when the commission certifies, the governor will have 60 days from January 8th.
Well, wait
in
a
fact,
second.
the court
So
said,
you don't agree with the Article 5, Section 11C doesn't allow nominations to be made until 30 days, within 30 days, meaning after the occurrence of the vacancies?
it doesn't say after,
It says
and that's what I'm
from
prepared to discuss.
Shall be, okay, so.
That's what
let
I'm
me-
prepared to.
That's what this oral argument is about.
That's what it's about,
Okay.
yes.
I
and
thought also, I wanted to ask one other thing, and then please address that, is that the deadline issue. Without question, it would appear that the day after the letter from the Governor Scott was sent, whether it was the chairman or whatever, and set the deadline of October 8th, which would have been then 30 days before the deadline. You would have had 30 days to make the nominations under that letter. With the fact that Governor Scott did not have authority to set that deadline, what is the position of what the JNC can do acting on its own without direction from the governor who has the authority to appoint?
Well, you want me to answer this one first?
Whichever one you want.
Well, let me get to the first question, because I think that's the fundamental question of interpretation of the constitutional language within. The Constitution provides that the nomination shall be made within 30 days from the occurrence of a vacancy. That language can be interpreted in several ways, as this court has said a few times. In Barco versus School Board, it interpreted the term within regarding Rule 1.525, which required attorney's fees and costs to be filed within 30 days of a judgment. And the court, in interpreting the term within, looked behind the purpose of the rule, and the rule had been changed where before it had set a deadline of a reasonable time, and some people were missing a deadline that they didn't know existed because reasonable time cannot be determined. And so the court said, in the context of this rule, within means no later than 30 days. You can file it before a judgment, but you don't have to wait until the judgment is filed to actually file a motion for attorney's fees. So it interpreted within as expansive in that context. Similarly, and I think it cited Chatlos versus Overstreet, another Supreme Court opinion regarding a tax assessment and when you can file to challenge a tax assessment. And the statute also used the term within 60 days from the time that the assessment is final. And courts had dismissed challenges to tax assessments that had been filed before the tax assessment became final. And the court said, no, we want to give them as much time as possible. So what if they file it before? As long as they don't file it after the 60 days has run on the back end, they can file it on the front end.
And in Barco, the language was within 30 days after filing, correct?
Yes, and the court still said.
And the court still said, we look at the plain meaning, and there's several, it could be read several different ways. The within could be, one is not later than, and that's what makes sense in context here. So even if from was interpreted as after, then Barco answers this question and says that they can do it beforehand.
Yes, Your Honor, and it makes perfect sense in this context, because this court in 1992 in the advisory opinion said that vacancies shall be limited to the extent possible. In fact, I'd like to quote a little bit of what the court said, because that's what JNCs have been following for the last 26 years. It says, vacancies in office are to be avoided whenever possible. We are confident that the framers of Article 5 intended that the nominating and appointment process would be conducted in such a way as to avoid or at least minimize the time that vacancies exist. So JNCs have been following this, and in fact, the practice uniformly for the last 20 plus years has been that the JNCs start the process and even make the nominations before the justice or judge leaves office. There are no exceptions to that rule for any of the justices on this court or for judges on the District Court of Appeals.
Well, it hasn't been, but you would agree that also it hasn't been challenged. And I want, just going back to,
I agree, yeah.
And in fact, in the advisory opinion where you wrote your concurrence.
Brilliant concurrence.
The Governor Bush, requesting the advisory opinion, assumed that if the constitutional vacancy is the starting point for the process, that there would be a 120-day vacancy. So all we're really talking about here is, again, you and I, to me, the nomination process is coterminous with the certification. And I don't think that there's ever been a challenge because it hasn't been an issue for several reasons. It's either the same governor or it was worked out. But we have something very different today that we never had before, which is a challenge, and also, frankly, that the JNCs at the present time are markedly different from what they were in the year when Justice Quince was appointed, because all of them are essentially appointees of this current governor. That has changed the nature of the JNC. But for you to say it's been done that way doesn't mean that that is constitutionally the correct interpretation. So I know that you'll appreciate that it's been assumed in that 2006 opinion that it would have had to start at the point of the vacancy. Would you agree with that?
The
letter to the governor.
No, I don't think it does have to start at the point of the vacancy.
That the governor assumed that.
I'm sorry?
The governor, in the letter to us, in which the advisory opinion was issued, assumed that the vacancy would start the process.
Well, Your Honor, that was regarding Judge Irvin, and even after this court's opinion, the first DCA Judicial Nominating Commission sent out applications and nominated before Judge Irvin left office. So even having that opinion, the JNC interpreted it as allowing them to nominate before the vacancy actually occurred. I think in January or whenever it was, they nominated before then. And
Mr.
regardless of
Cantero,
how,
would you
sorry.
respond to this? This is very troubling to me that if it's not coupled with the concept of vacancy, then a governor or a JNC, everyone knew 6 years ago the ages of the justices, so they could have acted that many years ago. There's, according to this argument, it has nothing to do with the timing of the vacancy.
Your Honor, that has never happened in the history of the
Well,
nominating
I didn't
process.
say it. We're playing word games here this morning. And I'm asking you that with the theory that's being advanced is that if it's not tied to the vacancy itself, then they can act at any time, including when it's known that somebody may be leaving 6 years ago.
Your Honor, I think that would be unreasonable, and a quo warranto would be available at that point, but that has never occurred. And
Well,
we
but I mean,
shouldn't be-
there's nothing that would stop it according to the arguments that are being made. If it's not tied to vacancy, the actual leaving of
Well,
office,
when a
then it can be done.
No, when a vacancy occurs, meaning we know that a vacancy is going to occur imminently, it doesn't, you have to
Where's that-
interpret
where's
those words
imminently come from?
reasonably.
Well, where does imminently come from? There's no imminently in there.
But you have to
You're
interpret-
arguing on one side that there's no restriction at all.
You have to interpret those words reasonably, since you're interpreting the Constitution. You have to interpret them in a way that would comply with the Constitution, not in a way that it
Well,
won't
they would
comply
comply
with the
Constitution because according to the argument that I'm hearing, this process is not really tied to vacancy.
It's tied to a vacancy, Your Honor, but if the process couldn't even start until, let's say, January 8th, then you're actually maximizing the time of a vacancy. Because the vacancy, they couldn't even send out
Well,
call
I
for
understand.
applications.
No, well, I understand that. I'm asking about the argument that you're making, that it's not tied to vacancy, and so where's the point that they cannot operate? According to the theory and the argument that you're making, is that they could act at any time on their own motion, their own activity.
Within 30 days of an occurrence of a vacancy can be interpreted 30 days before, 30 days after, unless granted by the governor another 30 days, which is what happened in this case. They were going 60 days back, 60 days forward, not back as long as you want, not infinitely back. It's 60 days. So, and that's an interpretation that complies with the plain language of the Constitution. 30 days before or after, except if the governor gives you an extension, then it's 60 days before or after. It's not 2 years before. Justice Polson, I think.
Did you address Mr. Mills' argument that you need to comply with your own rules? And so the application process should not be complete or actually, under his argument, begin until January?
Yes, Your Honor. What the rules say is when a vacancy occurs, the JNC shall call for nominations. The JNC, and as all JNCs have this same language. The Supreme Court JNC, all 5 of the DCA JNCs have that language. They have all interpreted the language in their rules as when a vacancy is imminent, so that they can start the process and comply with the goal of the Constitution to minimize the time of a vacancy. And I think it's worked pretty well. Nobody has complained that hasn't worked for the last 20 years. Frankly, Your Honors, I think this is much ado about nothing. I'm still struggling to find out what we did wrong.
Okay, so let me go back to my question about nominations. And again, in light of what we said, which is that the governor has 60 days from when the nominations have been certified, those would be certified by who? By the Judicial Nominating Commission, correct?
Yes.
Okay. If you read that in conjunction with the first sentence, I don't see how you can say, and maybe it's that nominations, which is the names, go out any earlier than when the new governor takes office, and most respectfully. But let's go to the second point, which is that can they start earlier? To follow up on what Justice Lewis asked, has it ever been the case that the JNC has acted on its own as opposed to direction from the governor that's in office to start the process?
I don't know the answer to that question. I don't know if that's ever happened.
I mean, I think, with all the
Usually they use
appendices,
it
I would
as a
think.
precipitating event. I'll say that, let's just say in the vast majority, without saying never, never, they use the governor's letter as a precipitating event. Not that they have to do it, but it tells them now's the time. They can always say, no, we don't want to yet.
Isn't it, but this is the governor's JNC. I mean, this is the
Well,
governor,
it won't be the next governor's JNC for 3 years, so is that how long we want to wait until the governor has put his own JNC in there?
What I'm asking about, though, is that the deadline, I'm more concerned with the amicus position and what is being asked for, which is that because the deadline was set based on a letter given by Governor Scott, who we've now said did not have the authority to make those, to send that letter, and again, no aspersions on Governor Scott, it was in accordance with past tradition, that the process should not necessarily stop, but should be reopened for any additional nominations.
I don't think that has been any argument, and there's nothing in the Constitution that would prohibit a JNC from sending out a letter, even without a letter from the governor. Like I said, historically and traditionally, that has been the precipitating event, but it's not legally required. They can do it on their own. So whether Governor Scott had the authority or not is really ultimately irrelevant, because the JNC can do it on its own.
In your view, is there anything in the rules of the JNC to prohibit the JNC now, if it wanted to open applications and extend a deadline period?
No, Your Honor, I don't think so. I think that they can do that. And my biggest problem is the League of Women Voters, Common Cause, nobody ever asked the JNC to extend the deadline to call for applications until September 20th of 2018, which is when they filed this petition. We never got a call. Nobody called the chair or no letter saying, please extend the application deadline. Please ask for more application. There's uncertainty in the process. No, they went straight to litigation. Perhaps something could have been done. Maybe not, but we'll never know.
What would be, given the controversy and our order, what would be the downside to just opening up the process, another 30 days or something like that, and let some more people apply if they want to?
Your Honor, we've got 59 applications. Despite what the amici suggest, there are several African Americans, several Hispanics, several women, Asians who have applied. We have more applications than we've ever received, as far as I can remember, and I'm sure anybody in this room can remember, more applications than ever. There's no evidence whatsoever that we would get more applications. And in fact, when Justice Quince was appointed, they called for more applications. None were forthcoming. So there's no evidence whatsoever that it would do any good, and it in fact would do bad because it would delay the process. And I would think...
There's no evidence that other people would not apply.
That's right. There's no evidence either way.
If in fact this was such an artificial deadline, why not? I mean, I think that was Justice Labarga's question. What's the downside of opening the process at least another 30 days so that everyone knows you now have an opportunity? I mean, they knew at that point, but now the landscape certainly has changed somewhat with the issuance of this order on October 15th. And so what is the downside to doing that? If the certification can't be made until there's a new governor who's sworn in, then what's the downside? We're here at November 8th. That's going to take place in January. So what's the downside?
Your Honor, I am still of the position that we can nominate names before January 8th, and that will give the next governor the time to vet. Remember, there's going to be more nominees.
Well, let's assume that he can't until January 8th, that the nominating commission cannot until January 8th. What is the downside? That's 2 months from now.
I don't know that there's a downside, except that the Thanksgiving holidays and the Christmas holidays are coming up in November and December, and it's been a hard enough process trying to get everyone together for these.
Well, if people are that interested, I'm sure they will make accommodations.
We're talking, you said if the League of Women Voters had asked nicely,
Not asked nicely, asked before they actually file litigation.
Well, all right, but they did, and now all of the Florida Association for Women Lawyers, the NAACP, all the black lawyer organizations are asking this court, but also, I'm assuming, asking the JNC. It seems to me, if we're really trying to act in a way that's just, we've got something that's never happened before, which is 3 justices of this court will be retiring at the same time by mandatory retirement, that the second and third woman on the court are retiring, and that the only African American on this court right now is retiring. Given that, to say that with 3 vacancies that you had 59 applications and that's a record number, when it seems to be really not taking in the reality of the fact that there are only 6 African Americans that applied and 11 women. I would just, whatever this court does, I think that you, who have always acted honorably, could do a great deal by requesting the JNC to do just what at least is requested, to open it up for 30 days. If you did that today, it would perhaps stop a great deal of this continuing controversy. And so I respectfully suggest that the fact that there are 59 applications and that's such hard work, and that, you'd have to do more work. If there's a vacancy on this court for 30 days or 60 days, the court will deal with it. But we're talking about the next now, maybe 40 years on the court if you nominate a young enough justice. So this is a monumental time in our state.
I understand, Your Honor, and the question before the court, however, is whether the decision to do so or not to do so is so extraordinary that it warrants quo warranto relief from this court. I think that's what we're really here to talk about. And I can make that suggestion and that request to the JNC, and that's totally legitimate.
Well, I, for one, do not think the October 8th deadline was appropriately set, because it was based on a direction from the governor that has been declared invalid. So, and in response to what Justice Lewis said, well, they can just have acted, they could have started this summer or last year because it was such a monumental task.
I think I've answered that part, Your Honor, where I think the outside deadlines are 60 days one way or the other. So I don't think that should be a concern of the court. And as far as the authority, whether the governor had authority to do so or not, the JNC has authority to ask for the applications. And I know I'm running into Mr. Nordby's time, so I will sit down. Thank you. I ask you to decline to issue a writ of quo warranto. That's to the commission.
May it please the court. Dan Nordby on behalf of Governor Scott for what I think is a very limited purpose, the relief requested in the supplemental petition against Governor Scott by the petitioners here. But I wanted to talk at the outset about something that Justice Kennedy mentioned at the beginning of this argument, that this is, in all likelihood, the last time that this precise issue will ever occur as a result of the voters' adoption of Amendment 6. Absent an extraordinary, unprecedented circumstance such as a failure of the voters to retain a justice, the situation will not occur again. And as Justice Pariente mentioned in some of her questioning, in the past, the situation has always been worked out without controversy. The Governor-elect DeSantis, and Governor Scott have both stated publicly that they would desire to work something out without litigation here.
Well, is that the way our state should operate, is a couple of politicians getting together and agreeing what they want to do no matter what the Constitution says? Is that what you're arguing?
Justice Lewis, in the context of a discretionary writ brought by a party without...
No, I'm not talking about discretionary. I'm talking about our Constitution. You're suggesting that we should allow just a couple of politicians to get together and they on their own can decide what they want to do no matter what the Constitution says.
I'm not suggesting that at all, Justice Lewis. What I'm suggesting is that the way that incoming and outgoing governors have resolved this issue before has allowed for a process to unfold without any controversy. Justice Quince's appointment was made in that manner 20 years ago, and that nominating process
But I think you also
occurred.
have to take into consideration the lay of the land at that time. We had a different judicial nominating commission process, and we have a totally different kind of process today. After that, everything changed. Now we basically have a judicial nominating commission that is appointed solely by one person. You know, you hear and you read all about this is supposed to be a fair and impartial process, and there's no patronage and those kinds of things. But I think we have to really be realistic about the situation here. And so, yes, they may have gotten together then, but it was I believe there was a whole different landscape.
Well, Justice Quince, the supplemental petition that the petitioners have filed here has a lot of allegations and casts a lot of aspersions on my client and the members of the Judicial Nominating Commission. In the context of an original proceeding before this court, we're not really afforded the opportunity to respond to those sort of allegations. I'm glad that they included a transcript of that JNC training in their reply brief that was filed yesterday, because I would ask each of you to look at that transcript, at the training that was provided to the JNC members. Including Florida Bar President Ray Abedin spoke at the beginning of it about what he thinks is important in the bar's process, and the governor wants people to follow the law. The governor wants judges who will serve with humility. I don't think anything that he said is controversial in that process. As to the importance of diversity in the governor's JNC appointments, I believe this is the first time in history that a Supreme Court JNC making appointments has been comprised of 5 women out of the 9 members, all appointed by Governor Scott. Two members of racial minority groups on the Supreme Court JNC. So those are considerations that have been taken into account. And as to the idea that the governor has rejected JNC nominations, as he's allowed to do under the statute, he hasn't done that on this Supreme Court JNC. All of these members of this Supreme Court JNC were appointed off of lists that were submitted by the bar without any rejections to that. So with the governor and the governor-elect stating that the two parties with an actual concrete and particularized interest in the scope of the governor's executive authority, with neither of them raising an issue for dispute before this court, would suggest in the context of a discretionary writ that there would be ample room to discharge jurisdiction, whether it's on the manner suggested in our motion for rehearing or some other grounds, to allow that process to move forward. Thank you very much.
I never heard an answer to what would be, how would you have a quo warranto to stop nominating Justice Lawson's successors today if we're not correct? We have to be correct. As to whether there's going to be a gap, the longest gap that could possibly happen is if they go ahead and do what they're about to do and they make these nominations. And on January 8th, whoever's governor for the first time has that authority, they didn't get to any input, they didn't get to do anything. What are they going to say? Governor DeSantis is going to say it, I think, maybe not. It's up to him. I reject this list as a result of a tainted process.
We have, this idea that the governor can just reject a list because he wasn't involved. I don't know.
It's not because of that. He would have to have a tainted process.
But the idea of a tainted process, this is all totally speculative. It's political rhetoric. I think it could be viewed as such. And when I asked you specifically what was done that was wrong, you didn't name it.
Your Honor, I think I have named it. It's spelled out in our reply.
Tell me now.
It's a number of things, certainly. They set a deadline against their rules. They refused to open up the process to allow black and women applicants who say they're going to apply. Their membership shows forget their membership. Their membership shows that they're partisans, which raises, when other circumstances, the suspicion that they may have had difficulty putting aside their bias. Their rules say they are supposed to set the deadline backwards from the deadline. Page 29 of their training materials say, find out the deadline for making the nominations, work your application backwards. They've done the exact opposite of that. They have not held public meetings to conduct their actions. Their chair has unilaterally decided all of these things. There's a number of problems here,
Okay,
and it's not for me to prove. I haven't put it on
Your
evidence.
additional time is now expired.
May I have a
You
minute
can sum up in about 30 seconds.
Mr. Mills,
I would just-
Mr.
if
Mills,
I
let me
could-
ask you a question.
Yes.
You know, sometimes the law just gets so wound up in itself is that we overlook solving problems. Mr. Nordby tells us that this problem is going to be resolved with whoever's elected governor, what it looks like now, those two people getting together and working this out, so this is not a big deal. It's never going to happen again in the future. So we're just exercising our jaws here, that's what this amounts to.
Yeah. It's up to the new governor. If the new governor wants input from Governor Scott or anybody else, they're entitled to. And Your Honor, just to complete the answer to your question, you're right. There's speculation here. He's right. We don't have all the facts here. This is not the forum to determine that. The forum to determine that is the governor-elect, who is the person with the political discretion, to look at the circumstances and decide whether it's tainted.
It sounds like the best argument that you've made for why we should exercise discretion to enter an extraordinary writ under these circumstances is that it could cause more delay if we didn't, because the new governor can't do anything if he wants to until he takes office, and then that would just delay things more. And I don't understand that, given that we've entertained your petition. It seems like the new governor, if he wants to take action, could do it, the governor-elect, today or tomorrow. Again, is there a better reason for why we should exercise discretion to issue an extraordinary writ, even if we thought it was legally appropriate, rather than letting the new governor act if he decides to?
I think that only goes to the question of whether you should stop the process. And when there's a governor-elect, they could intervene to say, hey, we don't want the process stopped, or good God, please keep it stopped. And then you can hear from the person who has that authority. I don't, my clients don't, obviously. So I think that you should wait to see that. But on the quo warranto relief, that's not quo warranto, that's constitutional relief. The quo warranto relief doesn't depend on any of that. These are questions squarely for this court. There's no political judgment, and I hope this court
And
will
your
exercise
argument
quo
there
warranto.
is that we should address those issues because they're likely to recur.
I think that's a good reason to exercise your discretion. They're happening right now. You should answer this right now so that this isn't resolved by backroom deals. This is resolved by a court, so future everybody can know what the rules are and that the rules will be followed. Thank you very much.
Thank you.
Thank you
We
for the
thank you both for all three of you for your arguments.